All right. Welcome everybody to this month edition of African Liberty webinar. My name still remains Ibrahim Babatunde Anoba, and I am the managing editor at African Liberty. It's my honor to welcome you to another edition, but also to have to introduce to us today one of our the leading voice on intellectual property law in Africa, more so in the Southern Africa region. In the name of Professor Yeukai Mupangavanhu. But before we proceed, can you please help us pronounce your name properly, Prof, so we can have that nailed down?
All right, so it's Yeukai Mupangavanhu.
Yeukai. Can I say yes, Professor Yeukai for now?
That's all right.
Okay, great, awesome. So she is a professor. She holds a Doctor of Law degree specializing in trademark law from the University of Western Cape. Her experience lies in intellectual property law, particularly in trademarks and the law of contract. She has extensive experience teaching intellectual property law at both undergraduate and postgraduate levels, as well as undergraduate courses in the law of contract and advanced law of contract. Professor Yeukai actively participates in national and international conferences and forums where she shares her research findings, just like this one. Welcome, Professor Yeukai.
Thank you very much.
Awesome. So as our topic for today reads, intellectual property rights in Africa's prosperity, it's a combination of two things. First, property rights, then also how that factors into prosperity conversation of the continent. Because as you know, to a large extent, whenever we discuss prosperity on the continent, we often limit that to pure economics, or just simply supply and demand, and maybe in some cases security and political stability. But with the new resurgence in AI and whatnot, intellectual property seems to be coming up again as one of the critical questions to address when it comes to prosperity conversations on the continent. But before we dive into the nitty-gritties of the conversation, could you kindly, Professor, explain to us what intellectual property means, more so in the context of technology?
Thank you, Chair. Intellectual property in simple terms refers to human creation or ingenuity. So it protects intangible assets, and that can be in different forms. It can be music. So if you compose a song that qualifies as work that is eligible for protection under copyright. If you come up with an invention, whether it's a process or it's a product, that would qualify for protection under patent law. So when you talk about intellectual property, we are referring to that human creation or the fruit of your intellectual creation.
Okay, all right, so that's nailed down. But because this is mostly a conversation about property rights, I wonder how we can marry intellectual property on the one hand and economic prosperity or development. How does that two come into play? I mean, is there any correlation or divergence?
There is actually a strong link or relationship between intellectual property protection vis-a-vis economic growth and development. And this is because of the fact that when it comes to intellectual property, it is actually a catalyst for economic development. And I will give you some examples. So in Africa, like if you look at the issue of just the payment systems that have come up over the years, that have been something that has been helpful in ensuring that it's easy to trade in a number of countries, including Zimbabwe, for example, that keeps on changing its currency. But because there are various payment systems that then facilitate trade in those countries. And then you look at even the fact that we have got development in infrastructure general, be it in terms of the mining sector or be it in terms of the transport system, like there's a Kazungura Bridge, where you can see the fact that there's been development of a road network or a bridge that's linking about 4 countries. So that is a testament to the fact that when there is IP protection, then you create an investment climate. And when there is an investment climate, it means that you are going to have multinational companies being attracted to come to actually invest. And when they invest, there is employment creation, there is transfer of technology, and all that promotes economic growth and economic development.
Okay, so before I go to the next question, I just want to remind our audience to join the conversation by asking questions using the Q&A function. Post your questions there for Professor Yeukai, and he'll be sure to answer it. But Prof, so I live in the US, and one of the conversations we often grapple with is the borderline between what you want to consider intellectual property and freedom of, should I say, open knowledge. So there is this argument that, often goes as, okay, well, you cannot say you invent something and you just keep onto it without letting other people, take from that knowledge and build on it and create new things. And of course, there is a category of people that say, well, if someone creates something, then that's their own intellectual property, that's their own right. So I don't know if that debate is something that we grapple with in Africa. Is there a fine line or a complex line between what is considered a genuine creation of somebody or an individual versus how that creation could be used by others or open to other people to grab from, to enlarge or to use in some way? Does that make sense?
Yes, it does. From where I stand, I think that when it comes to intellectual property, yes, there is monopoly that the IP holder gets. For example, when it comes to an invention and a patent has been granted, you've got exclusive rights over your invention for 20 years. And if the 20 years lapses, then it means that that invention falls into the public domain and anyone is able to then make use of that technology. So if one then thinks deeply about the amount of time and money which is invested in research and development, I would think that to a certain extent, it is justified to actually have an IP holder having those 20 years. Because if, for example, it's pharmaceutical medicines or drugs, the clinical period and the issue of getting licenses and all that, it takes time. And by the time the product is on the market, maybe the IP holder is left with 11 years or so. So that means that you only have got 11 years to recoup your profits. And I think that if IP holders do not have that guarantee that they are going to be able to recoup their profits, they are going to keep their inventions a secret. So at the end of the day, society at large is going to be prejudiced.
So before I ask the question, are you talking about, so the 20-year rule, does it apply to all countries inside of Africa, or are you talking about one specific country?
When it comes to patents, if we look at the international instruments, like the agreement on trade-related intellectual property system, which is the TRIPS agreement, that is under the World Trade Organization, it says that member states are supposed to grant 20 years for a patent. So if you are a member of the WTO, unless if you are a least developed country, you don't have a way out. You have to grant 20 years for patent.
Okay, I might be wrong on this, but I think in the US, it's probably 100 years, or maybe a little bit less than that, because I don't know if you followed the news recently with Mickey.
That is copyright.
Okay, copyright. Okay, cool. So anyway, for many of us who are not actually experts in that legal field, what's the difference between copyright and intellectual property rights?
Okay, so copyright are exclusive rights that are granted for works. So there are different categories of works. For example, your sound recording, your literary work, your music, your literary work like your books, your poems, that would fall under literary works. And then computer programs, depending with the jurisdiction that you are in. For example, in South Africa, computer programs are also protected under copyright. Cinematography films would also fall under copyright. Broadcast program carrying signals, all that qualifies as copyright or copyrighted work. When you've got a copyright, in most cases, depending on the class or depending on the work that you are protecting, it's usually for a lifetime plus 50 years.
Okay.
For example, if it's a musical work or it's a sound recording. So with copyright, the term of protection is a bit longer than it is for a patent or than it is for a design. A design is only for 10 years.
Okay. So we got some questions now. And I encourage us, whenever we ask our questions, let's put the country where we are typing from. Let's address the first one from Vushilo Raphael. I think they are saying, you should please advise which institution an individual can apply to for for international recognition of patents. So maybe to expand that question, the African entrepreneurs, several of them that we all know, who have found it difficult to find their footings in international startups or technological innovation businesses. So is there something called, or is there something as such that you can recognize, that you can register your patent or your product internationally, rather than just say in South Africa alone or in Nigeria alone? Is there something like that?
All right. So there's a principle which is called the territoriality principle, which just says that the protection of intellectual property is within the borders in which that IP was registered. But there are, however, other ways in which you can submit one application, but you then mention a number of countries in which protection is sought. So which means it's still up to those countries to then decide if they want to register your IP or not. So it gives like space to member states or to different countries to decide whether in this case they would want to give you protection or not. So in terms of patents, there is what is known as the patent PCT, Patent Cooperation Treaty, which allows you to just submit one application and then you mention the number of countries in which you seek protection. And it is provided for under the World Intellectual Property Organization. But like I am saying, it's territorial. The protection is territorial. When you get or when you register your patent in South Africa or in Nigeria, you only get protection in Nigeria. But where, for example, your application went through ARIPO, I'm not sure if people are abreast with ARIPO, but ARIPO is a regional or a sub-regional intellectual property organization, which caters for mostly English-speaking countries, but it has got also Angola, Mozambique, which are Portuguese-speaking countries. So you can also submit your application through ARIPO and then mention the countries in which protection is sought. And then those countries would then decide whether they are granting you protection or not.
Wow. So basically your IP, if secured in South Africa, is very vulnerable in Nigeria.
Yes.
I mean, that sounds so interesting, because with this age of super integrated social media, super integrated communication mechanism, people can easily grab from what you've invented in South Africa and replicate it in Nigeria. I mean, isn't that scary? Do we have a way around that?
Yes, but that is why in this case, if you think that there is a risk that your invention might be exploited in Nigeria, you have to seek protection in Nigeria. So when you do your application, you have to also include Nigeria. So there is also what is known as OWAPI. OWAPI is also a sub-regional IP organization, which is for mostly the Francophone countries. So if you intend in this case to to kind of get protection in mostly the Francophone countries. You submit one application under OAPI, and then it is different though. So under OAPI, which is for the Francophone, if you submit one application, then you are actually not going to be required to kind of identify the different countries, which means their protection is more like regional because their laws are unified. Whilst in terms of ARIPO, their laws are harmonized. So OAPI, like the countries are almost like treated in the same way. They don't then vary or deal with the countries, the member states, as if they are development. So there are advantages and disadvantages to that kind of a system. But like I'm saying, in terms of IP, you get protection in independent countries, and you can submit one application, but protection will be either regional or it can be individualized.
So the picture I'm getting is that it's going to be difficult for, say, a young entrepreneur who has invented something or just create something and they want to protect it it's going to be difficult for that individual to do that compared to, say, a multinational corporation. So in this game of IP protection, it seems as though the bigger you are as a company or as an entity, the more chances you have of protecting what you've created compared to, say, just a single person, a single, engineering student in University of Cape Town who has created this massive thing. It's difficult for that person to protect their IP compared to, say, a bigger corporation. So if that's the case, so what are we doing to make sure individuals, small people like Mark Zuckerberg from 2005, kind of Mark Zuckerberg in the University of Cape Town, will not have their creation taken away or been stolen or been misused? Is there any law or any conversations ongoing that will protect such, younger, more personal, simple individuals?
So it depends with where you are. If you are in the university set up, then most universities, they've got technology transfer offices that specifically deal with the issue of IP and protecting the IP that is generated at universities. So they will ensure that you get your IP gets protected, and that you also maybe get a company that can commercialize. Or sometimes you can get the patent,
But I'm
but
not sure that's going to be other
commercialization.
universities. I'm maybe South African universities, but I'm not. I'm from Nigeria. I don't want to criticize my country. I'm not sure I've heard that on my campus before. But let's even forget those universities. What about people generally on the streets who have created, things? How can they protect their own, invention too?
You will need to get an investor. So I'll give an example of an inventor called Chikumbuzo in Zimbabwe. He has come up with different products, like I think that uses solar, like a car, there's a helicopter, a number of projects, but he has not been able to patent those products. And it's simply because he doesn't even know. Because when you are applying for a patent, you need to be able to disclose your invention. So if you are not someone who is really like abreast with how to draft the claim so that your invention can be protected, it means that you are either going to find yourself in a situation where your invention is not properly protected because you did not properly draft the claims, and you did not also properly describe the invention. So you need people who can then help you with the drafting of the documents that are required, like the forms, as well as people who are going to commercialize the invention itself. Wow. So it's not easy and it's not cheap when you want to protect your invention, for example, but there are ways in which you can get like someone who can someone who can give you financial backing to realize your invention.
I'm sure we have a lot of work to do when it comes to educating people on how to get investors or even protectors. I'm so sure not many people are so abreast with the complexity of this process. But anyway, let's try to address some of the questions we have. Let's try to answer the first one from Isaac in the Yeshimiye. And they're saying, what is the impact of IP on innovation, entrepreneurship, and technological transition in Africa? I guess we can simplify that by saying, as we are looking at economic reforms across the continent, what role does IP has to play in that? Maybe you want to answer that in 1 minute.
Okay, so like I said, that IP is what promotes innovation. So if you're going to have people who are going to be creative or who are going to be inventive, they need to know that their IP is protected. And when there is an investment culture or when there is an investment climate, and then people can easily then invest in R&D, and they can actually create new products, create new processes, because there is a reward system, there is an incentive for them to create something.
Got it. Okay, let's go to the next question by Americo Joaquin Eugenio. And they're saying, I'd like to know the number of years that someone takes imprisonment across border without passport. Okay, I don't think that's related to what we're discussing. There's a question from okay, yeah, we already answered that one. But yeah, Prof, let's think about, because we have the people that often join our webinar are young people, mostly recent graduates, people who are doing public policy, journalism, and intellectual entrepreneurs generally. So I was wondering if you want to speak to that category or demographic of young Africans who are journalists, public policy analysts, intellectual entrepreneurs, about their role in this IP conversation. Because I guess as journalists, we're not inventing too much. We are not engineers or scientists that way. But what role can young Africans of this demographic play?
I think is as citizens in the African continent, we have got a voice. But we can only have a voice if we know our rights. So the first thing is to ensure that you know your rights, and you know the fact that whatever you are creating or you are inventing actually qualifies for protection. So I think one needs to just educate themselves on the basics when it comes to IP. And there is a lot of help or support that is provided even for emerging inventors or creators under the World Intellectual Property Organization. They offer courses to member states in developing countries for free. And then they can also provide support in terms of technology transfer. So there's a lot of stuff that you can get if you just go even to the website itself, apply for those courses, and ensure that you know what you're supposed to be doing and how you can actually protect your rights. Because the issue of exploitation of rights is real, that someone can take your idea and they make money out of your idea.
Especially, I'm very sure I'm so confident that's going on massively in Africa when you consider some of the ideas created here, that you know clearly are being created in Africa, but all of a sudden you just see them being massively transformed in the US or the UK or Europe, and you're wondering how those technology get transferred across those spaces. But anyway, we have some questions. I think this is a very super interesting question by Nzia and Dollar, and they're saying, could you explain the dynamics between content generated by AI and IP law? Do rights belong to the promoter or the software developer, or to both of them in common? If, say, you create something out of AI, who gets the right? The AI software developer, or you who use the AI, or the both of you?
That issue is a hot topic at the moment, because we had a case, which is the Dabus case, which involved a claim that an invention had been made by an AI, that was generated by an AI, and that there was no contribution from the owner, who is Stephen Thaler in this case. So that has been to several jurisdictions. And the only country that granted a patent was South Africa. But then if you look at the law, the patent law, the regulations, they don't support the granting of the patent even in that situation, because like I said, when I was defining IP, I spoke about human creativity. So the law as it stands now, whether it's copyright, whether it's patent, it talks about human creativity. So there has to be human involvement. And you can use AI as a tool. Just like when you're an artist, you use a brush when you are painting. So that's the way the law is at the moment, that you can use AI, but there's human involvement, And therefore, as the human being, you are the one who is the owner of the IP. But where you say that this has been generated by an AI, then there is no protection as it stands. So that doubles invention has not been protected in several jurisdictions across the world because of that principle.
As if the IP thing is not already complex, then we had the whole AI thing. It's becoming even massively complex. Oh well, you lawyer, intellectual property lawyers, you have a lot of work to do these days. Okay, let's go to another question by Ojuan Byron from Kenya. They say, I would like to know if by any chance I apply for protection of my invention in a country and I get exploited negatively, do I get a compensation? In other words, do we have compensation for exploited invention? Because I mean, personally, if I'm in Nigeria and I invented something, I'll be so skeptical to submit it for registration or for protection because I don't trust the corrupt process in handling my patent. Do we have protections for that, especially for young people?
Yes, there are always enforcement mechanisms in every intellectual property law. So whether it's a trademark that you have and someone is abusing or exploiting your trademark, you have got protection. So which means you have to go to the provisions in the Act that speak to the issue of infringement of your rights and the remedies available when your right has been infringed. So under each law, there has to be infringement provisions in every country. Maybe the only time when it becomes tricky is when it's in another jurisdiction.
Mm.
As in, how then are you going to deal with that? Because then it means you need a foreign lawyer in that country now to be able to institute action against the third party that is actually reproducing your music or actually selling your books without permission, whatever the case might be. So cross-border litigation is what is complex, but otherwise, if it is within your jurisdiction, it's a bit easier.
Wow, that's a lot of money for young entrepreneurs to commit to. Seems as though for you to have your IP protected these days, you must have money. Otherwise, it's just going to be there. Okay, well, we have 4 more minutes to go. I want to ask one question. You're a faculty, a lecturer, and also a lawyer, as you know, and we oftentimes do not talk about IP created within universities by professors or things being created by them. I mean, I sometimes teach here in the US, and if I look at the chemistry or the biology department on my campus, it's so protected. Almost everything you do there is you are protected as a student if you come across if you stumble upon an invention. But I do not know if that exists for scholars outside the sciences, let's say in the humanities or even in the legal field. You create something, particularly universities across Africa. Do we see a type of conversation ongoing regarding how, IP or inventions or genuinely creations are protected by professors or faculties on campus in Africa?
So in the context of, for example, of South Africa, they are usually labor laws or employment laws. So which means you are now not only going to stick to IP laws, but you also have to look at employment laws. So when you sign an employment contract, in most cases, it will require you to then give whatever you're going to develop or what you're going to write. If I'm a lecturer and I write an article, it is published, the money is paid. It doesn't come to me, it goes to the university and they give me part of it. So I am the author of the article that I've published, but the owner of the work is my employer. So in general, that is the rule, that if you develop something during the course and scope of your employment, it belongs to your employer. But I've seen that in other jurisdictions like Japan now, if you develop something and your employer benefits from what you have developed, they're actually instituting claims now where they also get a part of whatever they would have developed. But I think in most countries, no, it's the employer who will take that credit.
Well, so that's one interesting thing I cannot wrap my head around, because again, you can understand the employer is creating the environments, creating the facilities, but again, in terms of, remember the AI debates, that there's human interaction, so that human must take the ownership of the invention. In this case, even though the employer is creating the software or the environment. It is the student or the professor that is actually making the research. So that's an interesting conversation to have. But our last question from Sunday Nuhu Audu, they said, I have a startup which is focused on promoting, I think they're from Nigeria. They said they have a startup which is focused on promoting eco-friendly activities, but the main challenge now is funds. And most of the investors I reach out to don't give me positive feedback. What should I do? And I guess this is the song you're going to hear from vast majority of our youth who consider themselves inventors, that they're not getting funds or investment from private investors. So what should they do?
Yeah, that's a tricky one because you need an investor to be able to get to realize that invention and be granted. You will need someone who can support you and someone who can help you to actually develop the product. So I think that one needs to just then see other things that you can get or other support that you can get within your country that can then assist you in actually getting your IP protected. But bottom line is you need an investor that can help you, especially if it's an invention. But you can sign contracts and then you can agree that you will, if this invention becomes a success, you will get a certain percentage, they get a particular percentage, so at least then there is a win-win situation. That's the only way out.
Wow. Okay. Well, I hope our friend Nuhu finds an investor, and your invention becomes the next big deal. Okay. Prof, any final salvo, any final remarks from you as we round off?
I want to just say that there's so much that is happening in our continent. So there is the issue of trying to now deal with IP issues as a continent, which I think is a positive development. And for those who are aware of the developments in terms of trade, there is the establishment of the African Continental Free Trade Area, which seeks to promote trade among African countries. And those countries have also agreed to an IP protocol, which is quite interesting because it seeks to protect emerging technologies and it seeks to protect traditional knowledge. Because I don't think that most of us, we regard traditional knowledge as a form of IP, but it is the most valuable to us as Africans. So we need to ensure that when researchers from overseas come to Africa and get our plants, and then they patent them as medicines, there must be a benefit sharing agreement with that community where they can also benefit. And then there must be prior informed consent. And that protocol deals with all those aspects, which I think is quite impressive.
You saved the best for the last. What do you say? How do you say it? You saved the last for the best, or the best for the last? Because that's actually one of my area of focus, where you look at the borderline between indigenous African forms of knowledge and how they are being mobilized or utilized for newer inventions and repackaged as something from the West, and now Africa is sort of excluded from rewarding or getting reward from that process. But anyway, maybe we can have that conversation next time. But Professor Yeukai, I want to say massive thank you to you for joining us, for educating us, and we hope you come up next time we invite you.